This monumental ruling from the nation's highest court represents a massive structural shift in how our fundamental constitutional liberties are actively defended, and it is sending intense shockwaves through every municipal police department and state legislature across the country. For decades, hostile state governments maintained a massive artificial advantage over your Second Amendment liberties by using broad, sweeping statutory definitions that allowed them to completely bypass traditional due process. By dismantling that automatic restrictive mechanism, the High Court has effectively forced the entire criminal justice system to reset its daily approach to how ordinary citizens are treated when they travel with tools for personal defense. This means the exact legal playbook used by aggressive local prosecutors to secure easy convictions during routine highway enforcement stops has been completely torn to shreds, leaving them scrambling to find entirely new ways to enforce total compliance. The immediate real-world result of this massive structural shift is that restrictive jurisdictions are already rushing to fortify their own regional codes to maintain absolute control over who can transport weapons within their borders. We are currently witnessing an unprecedented race where local lawmakers are passing emergency measures explicitly designed to replace the fallen restrictions with highly complex, multi-layered transport mandates. This means that while you might be safer from a sweeping statewide felony indictment based on an obscure property default rule, you are simultaneously facing a much denser minefield of overlapping municipal ordinances every single time you drive your family across a county line. The legal reality has transformed overnight from a single, predictable baseline into a highly fragmented patchwork of local traps that can catch even the most cautious traveler completely off guard. If you want to stay ahead of these rapid legal shifts and ensure your household is never left vulnerable to sudden changes in the law, make sure to subscribe to this channel right now. To fully grasp the true magnitude of what the Supreme Court just did, we have to look closely at the underlying tension between heavy-handed administrative overreach and your individual right to move safely through public spaces. The government long relied on the lazy argument that certain broad classifications of geographic areas could be entirely disarmed without any individualized showing of a specific, immediate threat to public safety. In this landmark case, the justices forcefully rejected that collective approach, declaring that the Second Amendment requires the government to meet an exceptionally high standard of proof before stripping a citizen of their rights. The court clarified that the historical record does not support a system of permanent automatic disarmament based on commercial proximity alone, which completely upends how local enforcement agencies have operated for decades. However, this monumental win for individual liberty carries a massive side effect that is playing out right now on our nation's highways and city streets. Because prosecutors can no longer rely on automatic property-based bans, local law enforcement agencies are rapidly shifting their entire operational focus toward active field impairment and strict container compliance during routine traffic stops. This means that when an officer approaches your vehicle window today, they are far more likely to conduct an intense, highly focused investigation into how your firearm is physically stored and whether you show any subtle signs of distraction. The intense pressure on these local officers to maintain public order means they are applying extreme scrutiny to physical details that used to be secondary concerns during a standard roadside interaction. Now that you see how the legal pressure is shifting straight to your local roads, I want to hear your perspective on this change, so drop a comment below and tell me if your local area is becoming more hostile or more supportive of your right to carry. The media framing of this decision is dangerously incomplete because they are presenting it as a simple win-or-lose scenario without explaining the intense tactical friction it creates for drivers every single day. They want you to believe that a unanimous or majority ruling from the highest court in the land acts as an invisible, magical shield that instantly protects you from any aggressive interaction with local authorities. The truth is that a Supreme Court ruling is not a roadside injunction. It is a legal precedent that your defense attorney uses in a courtroom months after you have already been arrested, booked, and forced to post bail. Officers on the street do not read full appellate opinions before deciding whether to place you in handcuffs, and many of them are being instructed by their departments to continue making arrests under existing state laws until those specific statutes are explicitly struck down in future individual lawsuits. Think of it like a professional sports game where the league changes a major rule over the weekend, but the local referees on the field keep calling the game the old way because they have not received their updated training manuals yet. If you try to argue the finer points of constitutional history with an officer on the side of a busy interstate, you are engaging in a high-risk gamble that almost always ends poorly for the citizen. The safest strategy is to maintain absolute tactical silence during the encounter, comply with all lawful orders regarding physical movement, and let your legal team use this massive new precedent to dismantle the state's case in a proper courtroom later. Here's what this means for you if you are trying to navigate this hazardous new environment while keeping your record clean and your family fully protected. If you are a concealed carrier who frequently commutes through major metropolitan areas, you must recognize that your permit is viewed by local authorities as an invitation to verify absolute compliance with every minor storage regulation on the books. We are entering an era where the exact physical placement of your handgun inside your vehicle can mean the difference between a polite warning and a devastating criminal charge that strips away your rights forever. If your state law requires a firearm to be encased in a locked container that is completely inaccessible from the driver's seat, then keeping it in a loose center console is an extraordinary risk that is simply no longer worth taking. Let us break down a realistic scenario involving a citizen who is driving home late at night after a long shift and gets pulled over for hovering too close to the fog line. Under the old system, the officer might have used a simple background check flag to launch into a generic line of questioning about property restrictions to see if they could trigger an automatic vehicle search. Under the new risk model, the officer will immediately look for any minor technical violation, such as an unlit license plate bulb or a delayed turn signal, to justify a prolonged roadside detention designed to observe your physical coordination. The safer behavior in this high-stakes moment is to keep your interior lights turned on, keep your hands visibly resting on the top of the steering wheel, and politely decline to answer any casual questions about your destination or your personal history. If you choose the riskier path of acting combative or trying to explain the latest Supreme Court voting breakdown to the officer, you are giving them the exact subjective articulable suspicion they need to prolong the stop. Consider another highly probable scenario where a driver is transporting their personal firearms to a local gunsmith for routine maintenance or upgrades. If you get caught in a sudden traffic backup caused by a minor accident, and an officer directing traffic notices a soft-sided rifle case sitting on your back seat, your vulnerability increases exponentially, depending on your exact geographic location. Before this historic ruling, the legal danger was centered on long-term property status questions that rarely came up during an ordinary visual observation from outside a vehicle. Now, because local departments are highly sensitive to the loss of their primary enforcement tools, that visible gun case can easily be used as a pretext for a safety check to ensure the weapons are completely unloaded and separated from any ammunition. Protecting yourself requires a total commitment to absolute visual discretion, meaning that every firearm inside your vehicle should be completely concealed from outside view long before you ever start your engine and pull out of your driveway. By keeping your gear stored out of sight in a locked trunk or beneath a secure cargo cover, you eliminate the initial visual trigger that causes an ordinary encounter to escalate into a full-blown constitutional showdown. A massive wave of hidden state-level regulations is quietly being prepared behind closed doors right now, and it is going to completely alter where you can legally park your car while carrying a defensive tool. So ensure you stay subscribed to this channel so you can see our upcoming deep dive into these aggressive new local zoning traps before they catch you unprepared. Our third scenario looks at a citizen who frequently travels across state lines to visit family members or conduct business in a neighboring jurisdiction that does not recognize their home state's carry permit. Many drivers operate under the dangerous illusion that the Federal Travel Protection Acts provide a blanket immunity that allows them to transport firearms through hostile territory without any local risk. The reality is that local police in restrictive states routinely ignore these federal travel protections during roadside stops, forcing the citizen to spend thousands of dollars on bail and legal defense fees just to prove their travel was entirely lawful. With the local governments losing their primary status-based enforcement tools under this new ruling, these hostile jurisdictions are becoming significantly more aggressive in enforcing their own unique definitions of what constitutes a locked and inaccessible container. This is exactly where the next major legal fight starts, as national rights organizations prepare a massive wave of secondary lawsuits designed to force these stubborn local police departments to respect the clear intent of the Supreme Court's decision. We are going to see intense litigation over the next few months, focusing heavily on whether local officers can use the mere presence of a legal firearm as the sole justification for a prolonged roadside interrogation. We must forcefully dismantle 3 highly pervasive myths that are currently flooding online forums and causing immense confusion for millions of well-meaning gun owners across the country. The first myth is the incredibly dangerous belief that because the Supreme Court ruled in your favor, all state-level vehicle transport restrictions are now automatically null and void. This take is completely false and can get you sent to a maximum security prison because the High Court only addressed a specific commercial property restriction, leaving all individual state laws regarding licensing, transport, and loaded carry completely intact until they are challenged and struck down individually. If you drive into a restrictive state with a loaded handgun tucked under your driver's seat thinking this ruling protects you, you are going to face immediate arrest and severe criminal prosecution. The second major myth circulating online is that police officers are no longer legally allowed to ask you if you have a firearm inside your vehicle during a standard traffic stop. The reality is that officers are entirely free to ask you whatever questions they want during an encounter, and in many states, you are under a strict legal duty to immediately disclose the presence of a firearm the moment the officer approaches your window. Failing to understand your local duty to disclose laws because you believed a false rumor online is a fast track to losing your carry permit permanently and facing immediate criminal charges for non-compliance. The third myth that is causing widespread confusion is the idea that this ruling completely strips local prosecutors of their ability to use your personal lifestyle choices against you in a self-defense case. While the government can no longer use status as an automatic baseline to brand you an instant felon, a local prosecutor can still absolutely use any evidence of substance use or improper storage to paint you as a reckless and irresponsible individual to a local jury during a state-level trial. This battle is not just a cold intellectual exercise about statutory interpretation, it is fundamentally about your ability to defend your home, your family, and your basic human dignity without being crushed by a hostile legal system. The law is a powerful and indifferent machine that does not care about your good intentions or your desire to protect your loved ones if you fail to follow the precise technical rules laid out by the courts. The three ultimate takeaways from this monumental decision are clear, urgent, and require your complete attention every time you prepare to travel with a firearm. First, the Supreme Court has firmly established that your constitutional rights cannot be stripped away by local governments through arbitrary, blanket classifications that completely bypass traditional, individualized due process. Second, the collapse of these automatic tools means that local law enforcement agencies are rapidly shifting their tactics toward intense roadside compliance checks, making absolute adherence to local storage and disclosure laws your primary line of legal defense. Finally, the legal ground is moving faster than ever before, and maintaining a constant, accurate understanding of these shifting rules is the only way to ensure you can protect your family while securely exercising your hard-won freedoms. We are building a powerful network of highly informed, prepared citizens who refuse to let sudden legal changes catch them off guard or leave their families vulnerable. So if you are ready to stay completely ahead of the system, subscribe to the channel right now and leave a comment below sharing how you plan to adjust your vehicle carry setup in light of this massive new ruling. To truly understand how deep this legal shift goes, we have to look at how local police departments are rewriting their internal training manuals this very week. For years, line officers relied on standard shortcuts to establish probable cause, which is the legal standard of clear facts that lets an officer make an arrest or conduct a full vehicle search. Now that the broad local shortcuts have been struck down by the justices, local departments are training their officers to look closer at the tiny details of how you interact with them during a stop. They are focusing heavily on things like nervous body language, how quickly you produce your license, and whether your eyes look bloodshot or tired from a long night of driving on the highway. This means that a routine traffic interaction that used to take 5 minutes is now being stretched out into a 15-minute roadside inquiry designed to look for state-level safety violations. If you are not aware of this tactical change, you might think the officer is just being friendly when they ask you how your night is going, or if you have had anything to drink. In reality, every single question they ask is a structured test designed to build a legal case that can survive in a state court without needing the old status rules. Knowing this means you must change how you view these interactions completely. They are formal legal proceedings happening on the side of a busy, dangerous road, and you need to treat them with absolute seriousness. The stakes have never been higher for the average citizen who chooses to exercise their right to self-defense while traveling through different towns and states. If you make a single mistake in how you display your compliance, you could find your property seized under asset forfeiture laws, which let the police take your car and your cash before you're ever convicted of a crime. This is why understanding the specific mechanics of your local transportation codes is just as important as knowing how to safely handle and operate your firearm at the range. Many gun owners spend thousands of dollars on advanced physical training and high-quality gear, but spend zero time reading the actual text of the laws that govern their daily commute. We are dedicated to closing that dangerous gap for our viewers by bringing you the exact legal breakdowns you need to stay safe on the street and in the courtroom. If you value this level of practical protection and want to make sure your friends and family stay out of these hidden traps, hit the share button and send this video to someone who carries a gun in their car. Let us take a deeper look at what happens inside a courtroom when a state prosecutor tries to salvage a case that would have been an automatic win under the old rules. Without the ability to simply show a piece of paper proving an automatic violation, the prosecution must rely heavily on the dashcam and bodycam footage recorded during your roadside detention. They will play that video in front of a jury and dissect every single second of your behavior, looking for any sign that you were acting reckless, uncooperative, or deceitful during the encounter. If the video shows you reaching around the cabin or arguing about your constitutional rights, the prosecutor will use those actions to argue that you posed an immediate threat to the safety of the officer. This is why your behavior during those first 60 seconds of a traffic stop is the absolute foundation of your legal defense, long before an attorney ever files a motion to dismiss your case. If you remain completely calm, keep your hands visible, and speak with absolute politeness, you are denying the prosecutor the visual evidence they need to paint you as a dangerous criminal to a jury. The ultimate goal of this channel is to give you the mental armor you need to survive those intense roadside interactions without giving up your rights or creating evidence that can be used against you later. We also need to look at how different states are responding to this ruling based on their local political environments and historical attitudes toward the Second Amendment. In freedom-loving states, governors are signing executive orders to ensure local police do not try to replicate the fallen restrictions through sneaky local administrative rules. These states are working to make vehicle carry more streamlined and less confusing for law-abiding citizens who want to protect themselves while traveling. On the flip side, restrictive states are actively collaborating with anti-gun organizations to create a highly hostile legal environment that punishes minor technical errors with mandatory jail time. They are creating massive multi-agency task forces specifically assigned to conduct highway safety sweeps along major interstate corridors known for carrying interstate travelers. These task forces are using advanced license plate readers and automated tracking systems to target drivers coming from states with permissive carry laws, looking for any excuse to initiate a highly invasive vehicle inspection. This means that crossing a state line is no longer just a matter of watching the welcome sign pass by. It is a high-stakes transition into an entirely different legal universe with its own unique traps. Think of it like stepping onto a completely different playing field where the rules of the game change without notice, and the referee is actively looking for any reason to throw you out of the stadium. If you do not have a clear, updated map of these regional legal hazards, you are operating at a massive disadvantage that can destroy your future in an instant. Our mission is to keep you fully mapped and prepared for whatever changes occur, no matter how fast the political winds shift in Washington or your state capital. The coming months are going to see some of the most intense legal battles over the Second Amendment in our nation's history, and we will be here covering every single update with the clarity you deserve. As we close out this comprehensive legal update, remember that true security comes from a combination of physical readiness, mental discipline, and accurate legal knowledge. You cannot protect your home or your family if you allow yourself to be taken out of the fight by a completely preventable legal error during a routine highway encounter. Take the time tonight to verify your vehicle storage setup, check your local duty to disclose laws, and ensure your defensive tools are stored in absolute compliance with the current statutes in your area. Stay alert, stay responsible, and stay dedicated to preserving the constitutional liberties that keep our families safe and our communities strong. We are proud to stand with you as part of this informed community of patriotic Americans who take their rights and their responsibilities seriously every single day. Make sure you are subscribed so you never miss a critical update, and drop a comment below letting me know what specific legal topic you want us to break down next on this channel.